In these videos, we're going to talk about cybersecurity law. Hopefully by the end of the videos, we will have covered three things. Firstly, what is cybercrime, privacy and cyber war? Secondly, the laws that govern privacy and cybersecurity, specifically in Australia. And third, the relationship between Australian and international laws. So cybersecurity laws in Australia cover cybercrime, privacy and data breaches, critical infrastructure, national security, and in that they cover metadata retention, assistance and access, and security agencies. And then international laws which govern Australia from an international perspective, and treaties and guides include things like the GDPR, the General Data Protection Regulation from the EU, the Convention on Cybercrime, and the Tallinn Manual 2.0, which covers an international treaty or agreement on cyber war. So law is the rules that are established by Parliament and the courts, which will be recognised and enforced by the courts. So it's important to realise that Parliament establishes laws as well as the courts themselves. All of these slides are from a presentation given by Dr. Kate Offer of the UWA Law School. So sources of the law: there are judges in courts, and they can actually create rulings on law that will then influence further court assessments. They work in the courts, and they create what is called common law, which is not something that's actually enacted through legislation in Parliament. There are politicians that will work through Parliament to create enacted law or statutes. So in Australia, we are covered by a constitution. The constitution is the ultimate source of all laws in a state or country, and it establishes who can make those laws. The Constitution will also define the scope of the government's powers and will place limitations on government power. Furthermore, the Constitution will also establish other institutions of government and grant these institutions certain powers, for example, the executive and the judiciary. So the executive being the politicians and the judiciary being the judges in the courts. Australia is also a federation. So it has a division of power between the states. So there are laws that are made up at a federal level and by the government, and also at a state level. And it's sometimes not absolutely clear which laws apply in which particular situations. So the Commonwealth of Australia Constitution Act, basically Section 109, talks about the inconsistency of laws. When a law of a state is inconsistent with a law of the Commonwealth, the latter shall prevail, and the former shall, to the extent of the inconsistency, be invalid. So that means that essentially when two laws between the state and the federal government, the Commonwealth, come into conflict, the Commonwealth will prevail and the state will be basically held to be invalid. So, as I said, we live in a federation, so are subject to both state and federal laws. Some laws are state, most criminal law, for example, and some laws are federal, taxation legislation, for example. You can tell by the name of the statute. So, the Road Traffic Act of WA, 1974, has WA in it. The Disability Discrimination Act of the Commonwealth in 1992 is a federal law. Judge-made law is also known as case law or common law or precedent. Australia inherited the judicial system and in fact most of our parliamentary system from the UK, where common law is also prevalent. Other common law countries include the US. So in Australia there's a whole series of different courts that at the top has the High Court of Australia. At the bottom, there are state tribunals going to state minor courts, state intermediate courts, the county or district courts, then to supreme courts, and then the appeals. Essentially, each of these courts deals with certain matters, and they can escalate if people appeal. In the Middle there we have the local courts in territories. So territories in Australia are different from states. They have their own system. And then on the left we have the federal courts, which start off with federal tribunals, things like the National Native Title Tribunal, for example, Administrative Appeals Tribunal, which go to the Federal Circuit Court, Federal Court of Australia, and then the full court of the Federal Court. There are two types of law. There's criminal law and civil law. So criminal law is concerned with offences against society, and the primary goals of criminal law are to punish and deter. Civil law are wrongdoings between individuals, and in this case companies are also treated under civil law, and the primary goal here is to bring about compensation for those crimes. Cybercrime is defined as crimes directed at computers or other information communication technologies, ICTs. Those crimes include things like computer intrusions and denial of service attacks. They also involve crimes where computers or ICTs are an integral part of an offence, such as online fraud. Cybercrimes are covered by state and federal acts. So there is the Criminal Code Act of 1995, the Commonwealth, which is called the Code. That was modified by the Cybercrime Act in 2001. And then there are state acts, for example, the New South Wales Crimes Act 1900. What distinguishes these two depends in part on what computers and networks were impacted. There is a situation where if any hacking could potentially be tried under Commonwealth law, because if you've used a network to access a computer, then that network is provided by an ISP or a telecommunications company, and that's covered by federal law, not state law, even though it may have happened within a state. There's a whole range of things that are classified as cybercrimes, so hacking, denial of service, phishing, introducing malware, distribution, sale, or offering of sale of hardware, software, or other tools used to commit cybercrime, possession of those tools. Again, if you are walking around and you have a laptop that has hacking tools on it, potentially the police could make a case against you. Although if you're a legitimate security researcher or work in the industry, that would be reason enough. Identity theft or identity fraud, electronic theft. Unsolicited penetration testing is a crime, so that if you think you're being helpful and you haven't got explicit permission to do that, then that could be considered a criminal act. And then any other activity that adversely affects or threatens the confidentiality, integrity, and availability of IT infrastructure, communications network, device, or data. Other types of cybercrime go into things like revenge porn, child pornography, cyberbullying, and terrorism. So revenge porn is where somebody has posted a photo of somebody else depicting them in a pornographic act, or basically taken photos and posted them. Child pornography is obviously pornography relating to children. Cyberbullying is another one which is unfortunately incredibly common. And then, of course, terrorism. One of the issues that has been raised is the debate between law enforcement and privacy. This centers around the use of encryption. So it's sometimes referred to as going dark. So law enforcement agencies claim that they require backdoors and ways of circumventing encryption technologies used in messaging and phones to be able to actually do their jobs properly. Civil liberties groups and individuals and companies argue that actually privacy and commercial protections are more important, and so that is why they need encryption, and that law enforcement have other means of actually doing their job without actually putting these backdoors or weakening the protections that they enjoy. So tech companies like Apple and others have increasingly implemented strong encryption, and that does not provide governments with access to devices and communications to ability to intercept those communications. This is often invoked in the need to fight terrorism and serious crime, so child pornography being one of them. And essentially, this may be a technical problem rather than a legal or policy problem. It may be possible to implement schemes where the systematic weakness of that technology isn't introduced, but it does give law enforcement access to essentially confidential information when they've got a court justification to do so. So technologies like encryption, cryptocurrencies, and changes in communications through social media and other electronic means has given rise to new and more pervasive crimes. It's hard to match the rise in volume and diversity of the crimes with law enforcement. So we can have policy and education that may address some of this, or we may use technological solutions like AI, but they may also have to be legislated. So what laws cover cybercrime? Well, in Australia, there's the Cybercrime Act 2001, which introduced specific amendments covering cybercrime into the criminal code. It provided definitions for data held by a computer in unauthorized access. So there were different levels of penalty depending on whether the data was impaired or modified in any way. So getting access to a computer and looking at what's on that computer is one thing. Obviously, going in and altering data is a more serious crime. The Cybercrime Act also provided exclusion for national security agencies in Australia, ASIO and ASD and others, and gave law enforcement specific powers. Firstly, to take equipment for examination, to use electronic equipment to gather evidence, and to copy data for evidence, handling it, and ultimately destroying it. So that was only actually brought in 2001. That was further amended in 2011, and this was specifically for Australia to ratify the European Convention on Cybercrime, where we'll cover that later, but this was a convention to try and normalize criminal laws across countries, mainly to tackle international crimes, so that if somebody committed a crime in a country but were based in another country, the hope of this convention was that it would give countries powers to actually deal with that. This legislation amendment also amends other acts. So there's the Telecommunications Act 1997, Telecommunications Interception and Access Act, Mutual Assistance in Criminal Matters Act, and the Criminal Code Act. Cybercrime legislation requires carriers and carriage services, so as telecommunication companies and ISPs, to preserve stored communications for domestic agencies and the Australian Federal Police on behalf of foreign governments. So this is part of the European Convention, essentially providing that access. Again, some other things to do with the European Convention on Crime basically created confidentiality requirements in relation to authorizations to disclose telecommunications data and expand offence provisions. So the European Convention on Cybercrime, actually also called the Budapest Convention on Cybercrime in 2001, was created by the Council of Europe and had the active participation of observer states including US, Canada and Japan. It's an international treaty harmonizing national laws, and it defines illegal access, interception, data interference, system interference, misuse of devices, and offences related to pornography and offences related to copyright as well. Another act that was introduced in 2015, which was the Interception and Access, so part of the Telecommunications Amendment, also called Data Retention Act. This amends the Telecommunications Act of 1979 and the Telecommunications Act of 1997, and requires that telecommunication services retain metadata from users for at least 2 years. That includes incoming and outgoing telephone caller identification, date, time and duration of the phone call, location of the device from which the phone call was made, unique identifier numbers assigned to particular mobile phones or the phones involved in each phone call. It also covers email, covering the same sort of data, and also access by web browsers as well. Unfortunately, one aspect of this is that 22 different agencies, including ASIO, the Australian Crime Commission, the ATO, Tax Office, and various others, can access the data without a warrant. So it meant that there was wholesale access of this data for a variety of purposes that went well beyond the arguments that were given at the time when this was introduced.